Welcome to our East Asian seminar series. Today's title and talk is going to be on, Is China Changing the Rules of the International Laws of the Sea? My name is Diana Fu. I'm an associate professor of political science here at the Munk School of Global Affairs and Public Policy, and I'm also the director of the East Asia Seminar Series at the Asian Institute. We are very pleased to be having a very distinguished panel joining us today, and I will very briefly introduce them. So first we have Professor Tom Christensen, who is a professor of public and international affairs and the director of the China and the World program at Columbia University. He arrived in 2018 from Princeton University, where he was also a professor of world politics of peace and war, and the director of the Princeton, Harvard, China, and the World program, and the faculty director of the Masters of Public Policy program and the Truman Scholars program. More importantly, from 2006 to 2008, he served as Deputy Assistant Secretary of State for the East Asian and Pacific Affairs, with responsibility for relations with China, Taiwan, and Mongolia. And he has written a lot of books. His most recent book is called Lost in the Cold War, the story of Jack Downey, America's longest held POW. He is also a life member of the Council on Foreign Relations and a non-resident senior scholar at the Brookings Institution. And he was presented with a Distinguished Public Service Award by the United States Department of State. So welcome, Professor Christensen. We are also joined by Professor Isaac Carden. He is a senior fellow for China Studies at the Carnegie Endowment for International Peace, and he was formerly assistant professor at the United States Naval War College, where I am told that more than one time he's taught on ships, which I think is very cool, China's Maritime Studies Institute. He is an international security scholar specializing in Chinese foreign policy and maritime strategy. His work has been extensively published in many top journals, and he's also delivered congressional testimony and briefed across the Joint Force and Interagency. And he is the author of a book that we will be talking about today, China's Law of the Sea, the New Rules of Maritime Order. And as you see on the screen here, you can save 30% with the code that is shown on the screen. So please go out and just click and order one right now. We are also very lucky to be joined by Ketian Vivian Zhang, who is an assistant professor of international security at the School of Policy and Government at George Mason University. She received her PhD in political science at MIT, where she was also an affiliate of the Security Studies program. And she previously held fellowships at Stanford University and the Balfour Center for Science and International Affairs at Harvard Kennedy School and the Institute for Security and Conflict Studies at George Washington University. And she also studies rising powers, coercion, economic statecraft, and maritime disputes in international relations and social movements in comparative perspective, with a regional focus on China and East Asia. So I want to give a very warm welcome to our panelists. So I wanted to start by inviting each of you, starting with Tom, by inviting each of you to say just a few opening remarks about, give our audience a sense of why the stakes are so high in China's behavior in the maritime world, both in the South China Sea and the East China Sea, and why we should care about this. So, Tom.
Okay, thanks. I'm really pleased to be here. Thank you, Diana. I wanted to start by saying people really should read Isaac Carden's book. I've read it twice now, and I got to see it in draft form when he was a fellow in my program, where he was a postdoctoral fellow in my program at Columbia. It was at Princeton at the time, and we're really proud of him as an alum of our program. So do look at the book. I would say that, in terms of the thesis of the book, I have a couple of differences with Isaac. And I think the South China Sea is important no matter what. And the East China Sea is important no matter what. And I think that on security grounds, it's a major potential source of conflict for China and its neighbors, and potentially a source of conflict between China and the United States. And all that is true. And Isaac Carden's book lays out some of the background conditions that could create the sources of those conflicts. But there's a broader narrative in the United States and in other countries as well that China is trying to rewrite the rules of the international system. And where I might have somewhat of a difference with Isaac is on that issue. I think that there are three ways to look at how China deals with the international system, multilateral rules, international laws, et cetera, and maritime law is one of those places. One is China could be trying to create new rules to apply to the entire world. And that seems to be consistent with the common narrative in the United States. A second thing is China could be ignoring global rules and norms when it's inconvenient for China in pursuing its own national interests in its own region. And three, China could be clearly violating international norms and rules for selfish gain. And my own take on this is that China, in places like the South China Sea, does a lot more of 2 and 3 than 1. That it ignores rules and it violates rules, but I don't think it has an alternative blueprint for the world. It's not trying to replace the current international order with an alternative international order, but it's still quite consequential that China is doing that. The reason that distinction is important is maritime law, as Isaac correctly points out in his book, is one part of the international order as we know it in terms of norms and rules. And if China was really trying to rewrite maritime rules, it would seem more likely that China was trying to rewrite all of the rules of the international system. And I just don't see a lot of evidence to support that. That could start happening and we should remain vigilant about it. But if you think about the difficulty of rewriting the rules of the international system, you'd have to have a very clear idea of what you wanted to replace the current system with. You'd have to have consensus within your own government about what that new blueprint would look like. And you would have to come up with an explanation for why that new blueprint would serve your interests better than the existing blueprint. And I really can't think of a country that has benefited more from the existing international system after World War II than China since the reform period started. So I'm not really sure why they would have an incentive to rewrite all the rules. So there are a lot of concerns about China's behavior in the South China Sea because it is rubbing up against several of its neighbors. One of those neighbors in the South China Sea is the Philippines, and that's a US ally. In the East China Sea, it's rubbing up against Japan, which is arguably the most important ally in Northeast Asia for the United States. And the United States, unlike in all of the other sovereignty disputes, has said that the US-Japan alliance applies to Japanese administrative control over the disputed islands. And that could mean, in theory, that a conflict between Japan and China over those islands could lead to a US-China conflict as well. So it's quite consequential. I think Isaac does a great job in his book of laying all that out. And if I could just finish by saying one thing about Chinese revising the international system, if that were the case, it would be incredibly consequential. And it may happen over time, but I don't see evidence of it yet. But it seems a little bit unusual that the accusations for revisionism of the international system are coming from the United States, particularly in the last 6 or 7 years. Because as Isaac points out in his introduction, the United States has really tried to go after big pillars of the international system itself in that period. So the period in which the United States has been most expressive about concerns about China rewriting the rules, the United States itself has been undermining some of the pillars that the United States itself created or helped create. So I think of the WTO, where the United States has been in violation of WTO rules and has tried to undercut the appellate system by not resupplying judges. I think of the JCPOA with Iran pulling out of that, the Paris Agreement we pulled out of during the Trump administration, the TPP, which the United States pulled out of. So it's important, I think, to look at these things from an objective perspective and see how revisionist China is, how revisionist the United States is, and what the consequence is for that international system, which I think has really benefited both the United States and China. And I think revisions to it could cause harm to both countries. So again, read Isaac's book. I agree with large parts of it. There's a certain part of the pitch that makes me nervous for the reasons I just cited. And there's no question that these problems at sea are major potential causes of conflict between two major powers and between China and its neighbors. And all of that is consequential for all of us.
Thank you so much for starting us out with all these big questions, especially about whether China is actually rewriting the rules, the norms of behavior at sea or not. So Isaac, since you're the author of this book, I wanted you to talk obviously about, the book and how you decided to write it and what the main thrust of it is, but also, could you also explain for our audience who may not be familiar with the norms of what it means to play by the rules and what breaking the rules or changing the norms actually looks like? Could you also explain that so we can flesh out some of the things that Tom has just proposed?
Well, thank you so much, Diana, and thank you, Tom and Kotian, too. It's really just a great privilege to get a chance to talk about the book and this important subject with you. And I'm very flattered that you're willing to engage and help tease out what I think are some of the most consequential issues that we're all grappling with in different ways. And I actually think Tom did a great job of teeing up some of the motivations for the book and the substance of it, frankly. And I would argue that Tom and I are actually in closer alignment on this question than he's made out. I think appropriately so. And I think the title, The New Rules of Maritime Order, in a way already conditions or sets the stage for that objection. And if it were up to me, I actually would have put a question mark on it because it's an empirical book. And I would actually say one of my big conclusions, and it's not one that I set out having in mind, is that precisely as Tom says, there's no real good empirical evidence that China has a systematic or universalistic view of what the rules should be in almost any domain. And we can talk beyond maritime, and I'll get into, as you asked, Diana, what these rules specifically are and maybe why they're important. But ultimately, what I find is that the effects and the degree to which China is changing the rules are very regionalized. There's a real story here, and the title, I hope, says it all. It's China's law of the sea. It has to do with areas that China claims as being under its maritime jurisdiction. And it's a story about Chinese sovereignty. Sovereignty becomes quite dilute at sea. There's a complex set of rules called the International Law of the Sea that have evolved over many centuries to basically regulate some of the interactions among states. And they really started to evolve under the Roman Empire, where the Mediterranean was the main conduit for all of their communications. And ultimately, what we're talking about here really substantively is a treaty called the United Nations Convention on the Law of the Sea. People often call it UNCLOS or UNCLOS. And sometimes you'll see a Roman numeral 3 after it, because it's actually the third effort to create a multilateral treaty instrument, conventional international law, that could specify and codify some of this long-standing international law of the sea. Most of that law, and in fact, the only part of that law that the United States formally recognizes, an important fact about this treaty, is the customary international law of the sea. The original one of these rules is called the cannon shot rule. This is the idea that basically a state's control over maritime space extends about as far as it can shoot cannon, because that's the space under which the state is able to exercise control. Technology and norms have changed quite substantially, and the rules that we're mostly talking about here are in fact quite distant from China's mainland territory, or apply quite distant from China's mainland territory. Those familiar with the maritime disputes, which really constitute the core of this book, this was my way of getting at this really consequential foreign policy conflict that China has had festering for decades, and that's become quite acute in recent years, is the basic object is whether or not the application of the rules, such as they're understood, this Law of the Sea Treaty, to which China is a party and to which, importantly, all the regional states with whom it has maritime disputes are also parties. It's what's the meaning of those rules? And so Tom raises some interesting points about different ways to think about change to rules, ignoring rules, violating rules. Some of that is actually under this broader category that I'm trying to look holistically at. How does China practice the law of the sea? I'm not trying to adjudicate if they're right or wrong or violating law or complying or in any way. That's not, institutionally, that's not a role for a scholar, a social science scholar, at least, frankly. But what I can do is look at the patterns of behavior, and that's what the substance of the book is, the empirical practice of China. And that means, what do they say the rules are? What have they, both to the outside, to the UN and international diplomatic forum, as well as especially internally, how have they developed the law, regulation, rules, and also capacities and resources and policies, operations, actual practice of their version of the rules on the ground. And what you ultimately see, and this will be the last thing I say on, is that there is no universalistic aspiration as regards these maritime disputes, at least. This is only a subset of the rules. That's what I'm looking at. I'm looking at the ones that are really in dispute with neighbors, things like boundaries, things like resources. When you look more broadly, what I see is that China has quite a specific set of maritime interests for which it has developed this law of the sea as a way of managing. And ultimately, the centerpiece of it is China's sovereignty, China's security, China's territorial integrity from their view. And it has a very concentrated regional effect. The broader question is, so what does that do to the international order? What does that do to a maritime order that at least has pretenses to be universal or global? And the answer I can offer from this is, I don't think anybody knows, but what we can say is, I don't think China is making the rules at that level, but it's clearly making the rules less effective. And that's kind of a slogan that I've realized as I've gone around to talk about this book to broader audiences. I think that captures more or less the effect that we're seeing. You could think of them diluting those rules. You could think about them narrowing the scope in which international law provides determinate rules or norms governing maritime space. And what we see is a space that gives play to China's maritime power in a more significant way. They're able, through practice, not just these coercive, high-end threats and use of force, which are things that have happened involving China in this space, not to be discounted, but more to the point, they are seeking to change the overall context in which their security exists in East Asia. And this is only one of several efforts in that line. And that part is systematic. There's not a global vision of it, but I believe it has some global effects. It certainly draws the United States into the region with a much more significant sense of the consequences of these maritime disputes, what could just be regional or local things, arguably. I'll stop there and open up to.
Yeah, but before Katian talks, Diana, if I could just say one thing, I agree with Isaac that by ignoring and violating, China erodes the international norms for the whole world because China is such an important actor. So I don't mean to dismiss the importance of it. It's just a question of what's going on. I don't see it as rewriting, but let me turn it back to you, Diana.
Sure. So Katian, I want to return to my original question about what are the stakes here, right? Because for many of us here, especially those of us who are not security scholars, China's behavior and the South China Sea or the East China Sea seems very distant. It seems not to concern us, but it does. Obviously, it does. And there's dangers in China violating the rules of the sea or changing the rules of the sea or making the rules of the sea less effective. And so could you give us a little bit more concrete examples to illustrate like what would happen to China-Japan relations, China-Philippine relations, if the rules of this, if China is shaping more and more or influencing more and more what goes on in those regions of the sea?
Absolutely. So first off, thanks for inviting me. It's really an honor to be with all of you. And I apologize in advance if you see me logging on and off because my internet connection is a little bit spotty at the moment. So as someone who likes to sort of forge a middle path, if you will, I'm going to give some examples that sort of straddles between what Isaac describes as rule changing behavior versus what sort of Tom describes as sort of a rule violating behavior. So I'm going to give some examples of how China tries to cut corners in international rules, not just on the law of the sea, but in sort of more in the broader sense, international institutions at large, especially pertaining to China's use of coercion. Because when talking about stakes, coercion has been, especially China's use of coercion, has been on the spotlight, and it could potentially pose national security threats to U.S. allies in the region, as well as potentially drawing in the United States. So the first example of how China tries to cut corners in international institutions or rules in general when it comes to its behavior in the South China Sea, I think it actually has to do with the use of coercion. So there's a full spectrum of how states can use coercion, right? Ranging from the less escalatory kind to, for example, diplomatic sanctions or economic sanctions. But as Isaac mentioned earlier, states can also threaten the use of force or even abuse force, right? To utilize basically military coercion. But what's interesting in sort of my past research in terms of China's behavior in the South and East China Seas, that we're seeing more and more frequently China's use of not necessarily military coercion, but gray zone coercion, right? So it's the use of civilian law enforcement organizations, think the Coast Guard ships or previously the Chinese maritime surveillance ships, to inflict physical damage to South China Sea claimants. Think Vietnam or the Philippines, which is a U.S. treaty ally. But the rationale for why China does that is actually try to reduce conflict escalation, because China tries to utilize gray zone coercion for plausible deniability. Especially think about the Philippines as an example. The United States is a treaty, the Philippines is a treaty ally to the United States. So China thinks that by using gray zone coercion right below the level of military coercion, it might reduce the conflict it might reduce the possibility of drawing the United States in. So that's, I guess, the first way that China uses to try to cut corners in regard to international rules. And the second way China has been utilizing to cut corners in international institutions in the South China Sea has to do with the use of economic sanctions, another form of coercion. So what's interesting about China's economic sanctions is that it's not the economic sanctions that you tend to think about. So, for example, when the United States or the UN imposes economic sanctions on, Iran or North Korea, it tends to be comprehensive embargo. But what China does in the South China Sea, for example, let's use the Philippine example again, tends to be very small and targeted use of economic sanctions. But what's even more interesting is that China tends not to explicitly state that it is imposing economic sanctions on the Philippines due to the disputes in the South China Sea. So what China does, it's what I call a just do it model. It just imposes sanctions, but it never links explicitly the behavior with the disputes in the South China Sea. So in one dispute in 2012, China banned Filipino banana exports to China for several months, but never ever in the official statements of the Ministry of Foreign Affairs of China, it never linked directly the ban on Filipino bananas with the disputes in the South China Sea. And in a way, it's China's, again, plausible deniability strategy to reduce WTO lawsuits, because technically using coercion on the Philippines is not necessarily a national security threats. But let me just end with a slightly more positive note in terms of how China might actually also benefit from rules of the sea or international institutions. China and the United States have been negotiating and have negotiated a code of conduct regarding unintended encounters at sea to reduce conflict escalation or to reduce accident. And I think China and ASEAN are also in the process of trying to negotiate a multilateral code of conduct regarding unintended encounters at sea. So we're not talking about the COC or the code of conduct in general, but we're talking about ways that China has been utilizing in order to reduce escalation, because after all, China wants to use coercion to get what it wants, but it does not want to get involved directly in a military conflict if it can avoid doing so. So that's pretty much what I have.
Thanks very much, Kotian. I really like the examples that you brought forth to illustrate the toolkit of the instrument really that China is able to exercise, including a terminology that I gather is quite important, which is the gray zone harassment. That I would like either Isaac or maybe Tom to circle back to it to just describe for non-experts what that is and whether China is really the only actor who does that, or if the United States also engages in that kind of practice. But I wanted to touch upon and move to the moderated discussion part that touches upon something that Isaac had said earlier about China's maritime behavior being shaped by its interests, specifically its interests in maintaining sovereignty and territorial integrity. And so could you, Tom, elucidate for us what role does sovereignty play in Chinese attitudes towards international law generally, and then how this also accords with its behavior in the maritime regions?
I can take that first, and maybe Isaac can add to it. My sense is that sovereignty always trumps international law and norms and rules and agreements when it comes to the Beijing's interpretation of how to behave internationally to further China's interests. I think that this is true in the human rights domain, where China has long before it was as powerful as it is today, resisted various human rights pressures on China from the outside world on the notion of sovereignty and the sovereign right of Beijing to control its own domestic environment. And more recently, and it's laid out well in Isaac's book, it's really been a question of, can you allow international law and international legal rulings by the Permanent Court of Arbitration at The Hague, the International Tribunal of the Law of the Sea, to strip away what Chinese leaders have thought for many decades was China's rightful map, that China had expansive claims for many decades going back to the KMT period, the nationalist period in China in the South China Sea. And China had expansive claims in the East China Sea to include what the Chinese call the Diaoyu Islands and the Japanese call the Senkaku Islands, and of course across the strait with Taiwan. And it appears that when international rulings and international norms and international rules run against these claims, China either ignores or consciously violates those international rules. And the place where I say consciously violates, the biggest example, and it's laid out well in Isaac's book, is where China does something called drawing straight baselines between islands in the South China Sea, which is a clear violation of the UN Convention on the Law of the Sea, because China is a continental power. And that right to draw straight baselines and then project economic and other rights from that straight baseline is reserved for what's called archipelagic states like Japan or Indonesia. So China is doing that in the paracels. It appears, as Isaac lays out very clearly in his book, it appears that China is preparing to do that in the Spratlys as well, which has huge implications for China's neighbors. Now, in terms of coercion, China has been very smart, I think, in terms of furthering its interests by either ignoring or violating these rules, by using gray zone tactics. What are gray zone tactics? It's below the military level of coercion. So that's Coast Guard ships, many of which in the Chinese case are as large as the Navy ships that it's countering in the Philippines and elsewhere. So these are big, challenging ships, but they're not PLA Navy. There's also a very large maritime militia in China, which are basically fishermen with guns who report back to Beijing and back to the Central Military Commission now. So this poses something short of a military response to challenges by other disputants. And it does something very clever, which is a little bit ironic in this case, because what it's doing is it's allowing China to stick to the letter of an agreement that China signed with its neighbors in the South China Sea in 2002, the Declaration of Conduct in the Sea, in the South China Sea with the ASEAN states, which states you can't use your military to assert your claims in these disputed areas. So China tries not to use its military. It uses its Coast Guard and its maritime militia and stays true to that one agreement, even as some of its claims and some of its challenges to its neighbors seem to be in violation with those international rulings in July 2016 and with the spirit or letter of the UN Convention on the Law of the Sea.
Thanks for explaining gray zone tactics to us. Isaac, back to you. Do you want to elaborate a little bit more on, this concept of sovereignty, but also give us like some examples too. Like I want to bring this to life, right? Like for people who are perhaps not really familiar really with that concept and how that matters for China. What is your sort of nightmare scenario in the South China Sea and in the East China Sea? And how do you think that China's actions would provoke the US?
Okay, well, thanks to all of you for putting a whole bunch of interesting stuff on the table. Let me, I guess, just say briefly on gray zone coercion before moving on to the sovereignty questions and looking at some examples of where I see it. Yeah, I think Tom captured exactly the definition of it, and Kutian has provided a lot of insightful texture as to how do you stay below the threshold of militarized conflict while being pretty coercive and trying to pressure other states to do what you want them to do. And the one thing that I would tack onto that is that the story I'm telling here is about how it's about the script for these gray zone acts. What is it that keeps them below these thresholds? It requires some domestic planning and organization to develop a Coast Guard that has legal description of its areas of operation and its jurisdiction and the types of things that it does. In China's case, these things can be quite nebulous and quite indeterminate. They're out there to protect China's maritime rights and interests. Haiyang Li, Quanyi, excuse me, a mix of rights and interests together. They have a legal as well as a political strategic mission. And that is something that you can actually watch in development. And some of our other colleagues have watched other elements of this. Kutian has been very deep on it. Andrew Chubb has been very deep on it. You can watch, and my colleagues at the Naval War College, likewise, you can watch how these legal rules, as Thomas pointed out, they're not in any way trumping China's sovereignty. But I would argue that it's not quite as simple, now transitioning a little bit to sovereignty, it's not quite as simple as saying sovereignty just overrides it and it washes it away. It's that their view of international law is infused by very, very, what Ian Johnston calls hyper-sovereigntist view of order, actually. And I guess this is circling back to that original discussion. If there's some universalistic type or international order level program in play, I think it's that. I think what China's offering is not an order in which universal transnational rules of international law, like human rights law that penetrates deep into the sovereign state, various types of the responsibility to protect norms that evolve out of that and that put at risk not just China, but as Jessica Weiss points out, authoritarian regimes generally have a deep and abiding sense of vulnerability that in part is structural. It's the nature of the international legal system and its evolution towards being much more ambitious in a lot of ways. It's much more universalistic. It may have stopped that trend in part because the United States is not very enthusiastic about international law, certainly not treaties either. But what I would say China's doing with sovereignty, and I'll give you some illustrations of how this might work, is they have put on display what their diplomats call a way of practicing in the UN-centric international order. What do they mean by UN-centric? What's the main characteristic of UN states? Well, Taiwan's not a member of the UN because it doesn't have sovereignty. I think that tells you everything you need to know about it. These are sovereign states. China happens to also have a veto, one of 5 vetoes of sovereign states there as well. So this is and this is why I think people rightly say there's not an obvious Chinese blueprint to overturn this. They like that basic structure because they have great advantages in a system of sovereign states that genuinely preserves sovereign autonomy, inviolability of sovereign discretion, or I believe they think that's a more advantageous system for them. And one way to, one of the framings that I put on this book is this whole discussion of the rules-based international order. And one of the implications of what I'm looking at is that China doesn't really have rule-like ways of pursuing these interests. Their interests in, sovereignty, among other things, in economic welfare and security, especially, obviously crowd that out. But what they're doing is offering a different model for how international law can govern international relations. So a key part of international order. And it's that sovereign states have a lot of discretion as to what their obligations are under international law. And this is a view that's actually quite popular around the world too. And I do think we need to be having the discussion about, we tend to wave away all the ideological stuff that we hear China offering to the developing world in other places, or even to places closer to to the United States and Canada, as being somehow, just a product of a warped communist system and an ideology that's obviously reprehensible to everyone. I would say far from it. Sovereignty as a core norm and of a sort of bulwark against all these international pressures, and particularly pressures against the regime security of various states, is something that China actually has quite a lot of traction on. And I think, just the last thing on this generally, I think this maritime dispute context is it's one of the leading edges of this development in China's view about what kind of an order it wants to live in. It cannot live with a law of the sea that denies it this strategic space that it feels it must have in order to survive. And I think that's the basic underlying piece. And so when we see examples of Chinese sovereignty in play, let me give I think the most vivid one is probably the most recognizable. It is the 9-line map, or its predecessor, the 11-line map, which is some kind of an expression of Chinese sovereignty. It's been described as that. It has not been definitively said what exactly it is, but it entails some type of rights that China believes ought to be recognized under international law, or rather, it entails some type of sovereign authority that international law cannot encroach or constrain. I actually think the latter way helps me understand it better. So sovereignty kind of crowds out, in some ways, some of the scope for international law to govern interactions at sea, to govern things like boundary disputes, which China has with every single one of its maritime neighbors as a result of having this quite assertive, I suppose, view of how to use international law as the way to push back, to pursue these types of gray zone activities. And law provides the operating manual, or the script, in a way. They're writing it down domestically. Here are the things that we're claiming, and they're not being all that specific, but they're being specific enough on things like sovereignty for you to understand why that's sort of the driving force.
Thanks, Isaac. And Kotian, I wanted to see if you could pick up on if, China's writing motivation, that unchanging, principle is that of national sovereignty, which I think it is, in other areas. I mean, I study Chinese domestic politics and study civil society and social movements, and it definitely is like, sovereignty. You cannot, as Tom pointed out earlier, like China rejects any interventions in the human rights sphere on the basis of sovereignty. But if that's the case, then what levers can be pulled to change or influence China's behavior, whether with the 9-lines or its behavior on the Spratly Islands or anything like that, given that that's the baseline? Oh, you're muted, Kotian.
Sorry. I think there might be two ways to look at it. And the first one is, that's when I'm a little bit more optimistic, at least in terms of maritime disputes in the East and South China Seas, in the sense that even though it is a sovereignty issue, but since we're talking about interests that China has, there is a very strictly defined interest hierarchy, right, in terms of Chinese foreign policy, with Taiwan being the core interest. That is non-negotiable. China is willing to fight wars with the United States if Taiwan declares judiciary independence. But when it comes to the South and East China Seas, and I'm talking about individual incidents or dispute, say with the Philippines on a rock or with Japan on the Senkaku Islands, there is a little bit more room, at least in my view, of maneuver or negotiation, in the sense that it's not China's core interest, although you might have heard about, like the New York Times report saying it is China's core interest. But my view is that China has never, at least the official documents, has never stated the individual disputes in the South and East China Seas as a core interest of China. But that means that there might be more room for negotiations between the Chinese counterpart and ASEAN counterparts. And in addition, as of now, if we're talking about the military balance in the South China Sea, China does have the upper hand vis-a-vis other, vis-a-vis other South China Sea claimants. And if we go by Taylor Fripo, which is one of our colleagues' argument, China has been more patient in regard to those disputes in the South China Sea. So the first point being sovereignty might be sort of there might be different degrees of sovereignty or different degrees of importance that China attaches to these different kinds of issues, right? With Taiwan being one category and those rocks in the South China Sea and East China Sea being a different category, and maybe a less escalatory and more negotiable kind of category. And the second point with regard to how, for example, the outside world can deal with the situation, right? How do we respond to, in particular, negative actions and behavior of China in the South China Sea, mainly coercion? My view is that the United States has a large role to play in this regard, because it's true that China cares about sovereignty, but at the same time, overall, I think it's a very cautious and rational behavior, and it absolutely calculates whether the United States will get involved in certain conflicts or disputes in the South China Sea, and it's also calculating the level of U.S. resolve in the South China Sea. So if the United States does not demonstrate the resolve that it's willing to get involved in certain conflicts in the South China Sea, then, or if we see the United States pulling out of the Indo-Pacific region in terms of phasing, etc., that might give China the signal that it's okay to do a lot more coercive actions with with ASEAN countries or South China Sea disputants there. And one example is that when the United States pulled out of the Philippines in the 1990s, China actually utilized military coercion, and there are documents suggesting that that China said specifically that there is a geopolitical vacuum that the United States has left in the 1990s. So the second, I guess, counter action would be probably trying to maintain military presence in the South China Sea, and to demonstrate, or at least to signal resolve. But I think it's a very difficult balance and act, because on the other hand, we have to think about how to reduce potential escalation or accidents, i.e. militarized escalation.
Thanks, Katian. That's very helpful explanation to think about China's sovereignty interests being ranked, basically Taiwan being the number one. If there's going to be war, like I told my students this week, because we're talking about Taiwan, that it's been called one of the most dangerous places in the world because, if there's going to be war, it's going to be over Taiwan, perhaps not over the Spratly Islands or Diaoyu Islands. But I wanted to pick up on something you said about, the United States' role in mitigating conflict. And I wanted to see if Tom could address one of our audience questions about how smaller nations can aim to basically work together with U.S. or other bigger powers to work together in some manner as a bulwark against China.
Well, I think that Isaac's book is kind of a subtext for Isaac's book. I think that the beauty of the UN Convention on the Law of the Sea is it provides a principled reason for countries to rally against some of China's assertive behavior in the South China Sea. And I differ from a lot of my colleagues in the China security field in that I think that the 2016 ruling at the Permanent Court of Arbitration was really consequential. China said that it was illegitimate and didn't show up and didn't push its case. But the fact that there was a very clear ruling that said that various claims made by China are not consistent with the UN Convention on the Law of the Sea, and various behaviors by China are either inconsistent or illegal under the UN Convention on the Law of the Sea, going back to the 90s, going back to Mischief Reef in the Philippines in 1994, 95, is really consequential because it provides a principled reason for other states to object to the Chinese behavior and maybe rally together in a way. It's important for the audience to know that the United States takes no position on any of the sovereignty claims in the South China Sea, and it relies entirely on international maritime law and norms to assert its interests and to assert its rights to do things like maritime transits and freedom of navigation operations in the region. That's an important limitation of what the United States does, but it's also an enabler because it keeps the United States out of disputes. If a small actor wants to drag the United States in, it can't assume that the United States is going to side with it over the details of the dispute. It's about behavior, not about the claims. And I think that's important. But one of the challenges for the United States are the Chinese gray zone operations. And Kutian's work is really great on laying out the different levels of responses that China has to assert its interests in the South China Sea. One of the challenges for the United States is the US Navy is not particularly well trained or designed to take on maritime militia, small boats with rifles, and the optics would be terrible if the US military did that. If you think about a CNN moment in which Chinese fishing boats are being blown out of the water by a US naval combatant. So it's quite clever of China to assert its claims in that way. But again, the United States is not really trying to get involved in the claims. And I think one of the things, and it's related to another question on your board, that people misunderstand is that a lot of, even admirals will do it, and Congress people will do it. And in these congressional testimonies, they say, $5 trillion of trade goes through the South China Sea. And we can't allow China to control the South China Sea because it could block the trade. I just think this is a red herring, that China has no incentive to block trade through the South China Sea, since a lot of that trade is related to China's economy. But what is at stake, and Isaac's book is very good in focusing on this and not on that issue of China blocking all of the trade in the South China Sea, is the rights of militaries to travel through that region. And China has a certain interpretation of maritime law that challenges the rights of militaries to operate in this huge swath of water. And it would be impossible for the United States and its allies to maintain their allied position in the South China Sea if the United States were to back down to these very expansive definitions of coastal states' rights and of sovereign states' rights in the international space and in the oceans. And I think that does have an impact on what one of your questioners raised about Canada's interest. I think Canada has an interest in that as well as an ally of the United States. But I don't really expect China to seal off the South China Sea from trade. It's a very dramatic thing to present in congressional testimony, but I don't think that that's the problem.
Wonderful. And I just want to interject for the audience that feel free, and please do pose Q&A through the Q&A button that you see on the screen. It's a built-in feature on Zoom, so please do stream in with those questions. Let's see, we have another question that just came in about any analogous efforts by other countries where regional powers also trying to reshape maritime norms in their own periphery, for example, India and the Indian Ocean or Iran in the Persian Gulf. If so, how does this absence of a strong regional opposition, whether the absence of a strong regional opposition, whether their action gets noticed? Didn't quite catch the last part of it, but anyway, the gist of it is that, what about some comparative cases of other powers in the nation trying to also shape maritime norms?
Should I take
Yes,
this?
Isaac,
Why don't you
Isaac.
take that, Isaac? Because it gets at the importance of your book. If these norms get eroded, it could have global implications. So maybe you can lay out why.
And I think the questioner asks a very sophisticated question here, and I think he knows some of the key players. He or she knows some of the key players here. So the short answer is I don't see any analogous efforts, but as Tom said, there's a lot more scope that China creates for other states to have their own interpretations, their own sovereign auto interpretations. They often call it an international legal doctrine, stuff that becomes quite divergent. And I think, ironically, Canada is quite a good case to look at, as is India. Maybe appropriate to this. One of the priming questions you'd ask us, Diana, that dovetails with this has to do with, how distinctive is China's law of the sea? And again, the short answer is yes, it's quite distinctive. And my book is a monograph. I'm not doing a comparative study, but in the course of looking through this and talking to lots of people about it, I've got some intuitions about it. I think actually Rachel Odell, who's now at the State Department, but a classmate of Kutian's at MIT, did a very interesting study with an explicit comparison going on. But it's quite difficult to do. It's really not apples and apples because of all the other things that we've been talking about today that are concentrated in the South China Sea. The confluence of these sovereignty disputes really distinguishes it from what is going on in other maritime disputes in other areas. So taking the case of India just comparatively, and I've heard this in a variety of different ways, if there's any other big, important, major maritime power in the globe whose version of the law of the sea, whose interpretation of UNCLOS, specifically the treaty about the law of the sea, is close to China's, it's India. The most egregious of China's claims, arguably, setting aside the 9-dash line, is what Tom mentioned, this idea that you can fence off big, not even islands in China's case, a bunch of submerged reefs, as well as artificial islands and some things that are just rocks in the middle of nowhere. Excuse me. You can draw a big line in the ocean around them, and then from that line project outwards huge zones in which you have sovereign rights and jurisdiction. But then, perhaps even more importantly, you entirely fence off the internal area. That becomes internal waters. That's actually sovereignty. And this gets to Kutian's point about the different sort of levels or intensities of sovereign interest. It's quite clear, even though they're claiming sovereignty over the waters inside that space, that's not the same category as Taiwan. It's not even close. And this core interest discussion, I think, was very unhelpful for everybody. There is the kernel of a territorial sovereignty dispute in all of these, and it's quite important, and China has a principled view on that. But as a matter of fact and a matter of interest and practice, of course, Taiwan is the most important. But the thing to say on Taiwan, first, is that this is not a book about Taiwan, because that is much more complicated set of questions, but it has implications for how we look at Taiwan in a lot of ways. You don't need to be Admiral Chester Nimitz to see that Taiwan is in the South China Sea and the East China Sea. That's the south part, that's the east part. So any of the military questions that we have about what's going on there, about the military balance, about the nature of a campaign in and around the Taiwan Strait, you're talking about China's position in the South and East China Seas. And there was a lot of attention to, and I think appropriately so, to China's efforts to build quite significant military bases across the southern part of the South China Sea to complement the ones that it already had in the northwest part. But, these are part of a continuum of China's quite urgent sovereignty and security concerns that are going on in the region. And I realize I dropped off on this question of my nightmare scenarios, but I think it dovetails nicely with Tom and Kutian's comments about what are the types of severe problems that you could see result from China applying its version of the rules. And I don't think you need to have much of a vivid imagination for it. You've already seen the threat and use of force, especially against Vietnam. And to my mind, that is, I don't know if that's the nightmare scenario. It's obviously not the worst case. You could always think of something worse here, given how much power is arrayed in this space: Chinese, American, Japanese, other. However, when we look at China's propensity for low-level conflict, something that Tom has written about for many years and with great persuasiveness in my mind, there is a particular place in their heart for coercion verging on militarized lethal use of force against Vietnam to control maritime space. And they did it in 1974 in the Paracels, in 1988 in the Spratlys. They fought a boundary war with Vietnam in between those. That's the last significant PLA use of force. This is not a coincidence at all. And one thing that Vietnam does not have in common with Japan and the Philippines is that it's not a US ally, and that China has made a point of coercing it to prove its points to other great powers. Tom could tell us a lot about this, what China intended by invading Vietnam, what it intended to communicate to the Soviet Union, and how it intended to affect the Soviet Union's power position in the region. And I think we see a similar problem there, and that this has the kernel again of a nightmare scenario in the sense that I think the United States would be in a very challenging position were China to really use lethal force against Vietnam and, for example, seize some of the islands that Vietnam occupies. It's worth noting, for those who are not familiar with this, Vietnam is actually sitting on more of the features, the islands or rocks or whatever you want to call them in the South China Sea than is China. 20 some odd.
Thanks for sharing with us, Isaac, what keeps you up at night, the various scenarios. And I want to end with two questions that Ke-Tian can choose from. We have one question about to what extent does international cooperation, or can international cooperation protect the environment in areas in the South China Sea in which China has contested sovereignty claims? And also, what's better, more international maritime laws or less, or maybe status quo, given that China doesn't seem to be following them at all?
Thanks for the questions. Both are great questions. And I think the second question, I'm not an expert on maritime law, so I would defer that to Isaac to think about in future. So for the first question, in terms of environmental protection, so I'm not an expert on environmental protection, but my understanding is that international cooperation might not have done as much to especially prevent China from, for example, reclaiming a lot of those rocks in the South China Sea, right? So a lot of the rocks that we talked about before in this original form, some of them are submerged. They're not islands, but what China has done since 2014-15 is to construct artificial islands on top of those rocks in the South China Sea, so that they're actually man-made islands. But my understanding is that this process has huge environmental damage, and this is a done deal, and there does not seem to be any sort of international pushback when China did that. And so my punchline is that international cooperation might not be sufficient, at least to prevent a lot of the things that China has done in the South China Sea.
Wonderful. Well,
another environmental thing is fisheries, and the fishery problem in the South China Sea is enormously dire, and the lack of cooperation in preserving the fisheries is very dire. And we have a fellow from the China in the World program named Tabitha Mallory, who's written very well on this, and one of Isaac's colleagues in that program. So yeah, so I would encourage people to look at that issue. It's very important to all the countries, and it's very important to the diets of all the countries. And the fishery levels are just so low right now because no one's really cooperating to maintain them.
Right, and fisheries is something of great interest to Canadians as well. Well, we unfortunately run out of time. I know there must have been more questions, but thank you so much. I personally, having very limited knowledge of this area, learned so much. Everything from gray zone coercion to visions of a CNN moment in which the Navy would perhaps have had to encounter Chinese fishermen. That sounds like a bad optics indeed. So thank you all for joining us, and stay tuned for our future events. This is our last official event. Well, actually, there's another one coming up, but one of our last events. And so please stay tuned with the East Asia seminar series. And I want to thank all of the panelists again for joining us. Thank you.
Thanks, Diana.
Thank you.
Thanks so much, Diana. Thanks, everyone.
Congrats, Isaac.
Thank you,
Yep.
Tom. Thank you, Ke-Tian, too. Have a great weekend. Bye-bye.
Bye.